Art 15. Alternative circumstances. Their concept. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other conditions attending its commission. They are the relationship, intoxication and the degree of instruction and education of the offender. The alternative circumstance of relationship shall be taken into consideration when the offended party in the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstances when the offender has committed a felony in a state of intoxication, if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstance. Alternative circumstances, those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and other conditions attending its commission. They are: relationship, taken into consideration when offended party is the spouse, ascendant, descendant, legitimate, natural or adopted brother or sister, or relative by affinity in the same degree of the offender intoxication. Mitigating when the offender has committed a felony in the state of intoxication, if the same is not habitual or subsequent to the plan to commit the said felony. Aggravating if habitual or intentional degree of instruction and education of the offender relationship. Mitigating circumstance. Aggravating circumstance. In crimes against property, robbery, usurpation, fraudulent insolvency, arson, in crimes against persons, in cases where the offender, or when the offender and the offended party are relatives of the same level, as killing a brother, adopted brother or half-brother. Always aggravating in crimes against chastity. Exception. Art 332 of CC, no criminal liability, civil liability only for the crimes of theft, swindling or malicious mischief committed or caused mutually by spouses, ascendants, descendants or relatives by affinity, also brothers, sisters, brothers-in-law or sisters-in-law if living together. It becomes an exempting circumstance. Relationship neither mitigating nor aggravating when relationship is an element of the offense. Example: parricide, adultery, concubinage. Intoxication. Mitigating circumstance. Aggravating circumstance. A. If intoxication is not habitual. B. If intoxication is not subsequent to the plan to commit a felony. A. If intoxication is habitual, such habit must be actual and confirmed. B. If it's intentional, subsequent to the plan to commit a felony, must show that he has taken such quantity so as to blur his reason and deprive him of a certain degree of control. A habitual drunkard is given to inebriety or the excessive use of intoxicating drinks. Habitual drunkenness must be shown to be an actual and confirmed habit of the offender, but not necessarily of daily occurrence. Degree of instruction and education. Mitigating circumstance. Aggravating circumstance. Low degree of instruction, education or the lack of it, because he does not fully realize the consequences of his criminal act. Not just mere illiteracy but lack of intelligence. High degree of instruction and education. Offender avails himself of his learning in committing the offense. Determined by. The court must consider the circumstance of lack of instruction. Exceptions. Not mitigating: crimes against property, crimes against chastity, rape included, crime of treason.